Hello friends, in today's lecture we are going to discuss the essential elements of crime or criminal liability. Now, in order to understand the essential elements of crime, we need to know an important maxim, that is actus non facitrium nisi mens rea. It means that in order to constitute a crime, the actus reus must coincide with mens rea. So when actus reus and mens rea they come together, then only crime can be committed as a general rule. Now it consists of two important elements of crime. First is the actus reus and second one it is the mens rea. Now firstly let us see what is meant by actus reus and then we will come to mens rea. Now actus reus, it is a physical element of any crime, and this particular physical element, it generally means the result which the law seeks to prohibit or the result which is prohibited by the law. So for instance, the causing of death by poisoning, causing of death by shooting, or causing of death by drowning, all these are the actus reus of the offense of murder. But sometimes the actus reus may also consist of the time as well as place. So for example, there can be the offense such as housebreaking by night. So here the timing is also an important part of the actus reus. Or sometimes the place may also be the part of the actus reus. So in the offense of theft on vessel, vessel that is the ship is the place where the theft shall take place. And if the theft has taken place on the vessel or on the ship, then it is a punishable offense under the Indian Penal Code. So sometimes even the time and place can be the part and parcel of the actus reus. So actus reus must be proved by the public prosecutor in the court of law, and if that actus reus is proved, then only the crime can be established in the court and the offender can be convicted. Now then we move on to second essential element of a crime, and it is known as mens rea. Now mens rea, it stands for guilty intention, or according to Andrew Ashworth, it means mind at fault. Now this indicates the mental element or the psychological element of any crime. So usually the mens rea is to be found out from the surrounding circumstances, because it is very difficult to read what is going on in the mind of a person. But if you gather the surrounding circumstances, then from the surrounding circumstances you will come to know what is going on in the mind of the person, or what was the state of mind of the person. And therefore mens rea, it essentially means the mental element of the crime, and it indicates the state of mind of the accused person. Now, as far as Indian Penal Code is concerned, the expression mens rea is nowhere employed anywhere in the Indian Penal Code. Still, the concept of mens rea is impliedly incorporated in the Indian Penal Code by using certain words which indicate the mens rea on the part of the accused person. These words include the words such as intentionally, knowingly, negligently, recklessly, wantonly, voluntarily, dishonestly, fraudulently, and so on. So these are the words which have been used in order to indicate the mens rea of the offenses against the human body or offenses against the property. And that's why mens rea is an essential element of any crime in general. Now, in order to understand the importance of mens rea, we have to know that many crimes are committed with intention or with knowledge or with negligence, and that's why mens rea constitute an important element of the crime. Now, intention, it means the desire to bring about contemplated result. Knowledge, it means the awareness of the consequences. Negligence, it indicates the absence of due care and precaution. Recklessness, it means the person knows that whatever he or she is doing, there is a certain risk involved in that act, and still such person prefers to take the risk. Then you can say that the person has acted in a reckless manner. Or in case of the offense of theft, the mens rea is indicated by using the word dishonestly or dishonest intention. And what is meant by dishonestly? Dishonestly, it means with the intention of causing wrongful gain to one person or a wrongful loss to another person. So there is a wrongful gain to one person and a wrongful loss to another person. Further, wrongful gain means the gain of property to which a person gaining is not legally entitled. And wrongful loss, it means the loss of property to which the person losing is legally entitled. So in that manner, the drafters of the Indian Penal Code, although they have not mentioned specifically the expression mens rea, indirectly they have incorporated the doctrine of mens rea by use of variety of words in various sections of Indian Penal Code, such as intentionally, knowingly, negligently, recklessly, wantonly, dishonestly, fraudulently, voluntarily, and so on. So mens rea is there very much in the Indian Penal Code. Now, although we say that in order to constitute a crime, actus reus and mens rea must come together or they must coincide. But there are a number of crimes wherein the crime can be established only on the basis of proof of actus reus and wherein the mens rea is dispensed with. So mens rea need not be established in the court because it is dispensed with by the legislature. So number of such crimes can be cited. For example, the crimes such as crime of bigamy, the crime of kidnapping, or the crime such as adulteration of food, these crimes, they do not require any kind of proof of mens rea because they are known as the strict liability offences, and being the strict liability offences, they can be established only on the proof of actus reus. So such offences are known as the strict liability offences. Now, if we go to certain case law on the topic of strict liability offences, then important cases they include the case of R versus Tolson, wherein Mr. and Mrs. Tolson, they were the married couple, and Mr. Tolson, he goes to United States from England for the purpose of trade and business, and he takes a ship for proceeding towards the US, but unfortunately it is reported in the news that the ship has met with an accident, killing all the passengers including Mr. Tolson. So Mrs. Tolson, she waited for more than 6.5 years, and then she took a decision to enter into second marriage. And the law in England is that if you do not hear anything about a particular person or you don't know about the whereabouts of a person for 7 years or more, then it is presumed that such person is dead. And that's why presumption of death is there. So Mrs. Tolson, she waited for more than 6.5 years, and then she thought that now there are no hopes that her husband will return, and therefore she entered into a second marriage. But after she enters into second marriage, Mr. Tolson all of a sudden came from USA, and therefore Mrs. Tolson, she was prosecuted for the offense of bigamy under the English criminal law. Now when she was prosecuted, the court was of the view that the offense of bigamy, it is a strict liability offense wherein the condition of mens rea, it has been dispensed with. So mens rea is not even essential in order to establish that the accused has committed the offense of bigamy, and therefore the court convicted Mrs. Tolson and she was given the punishment for the offense of bigamy. But as she believed in good faith that her husband has died, and she also waited for more than 6.5 years for entering into second marriage, very less punishment was given, that is 1 day imprisonment was given. But still the punishment was given because bigamy is considered as a strict liability offense. Now apart from this landmark decision R versus Tolson, there is one more decision on the point, that is strict liability offense, and that is known as R versus Prince. Now in this particular case, Prince, he took a girl by name Annie Phillip, and she was under 16 years of age. Now, if any person takes away the girl below 16 years of age without the consent of the guardian, then it amounts to offense of kidnapping under the English criminal law. Now, the girl Annie Philip herself told Mr. Prince that her age is more than 16, and since she herself told that her age is more than 16, Prince also believed her statement as a true statement, and that's why he went with Annie Philip. Now, the school record, however, indicated that the age of the girl Annie Philip, she was of less than 16 years of age, and her age is below 16. That was proved on the basis of the school documents. And therefore, the question before the court was that whether Prince can be convicted on the basis of the school documents which were produced to prove that the offense of kidnapping has been committed. The court accepted that Prince believed that the statement of Annie Philip was a true statement, and that's why he took away Annie Philip, and that's why the question was that whether still he can be convicted or not. The court was of the opinion that the offense of kidnapping do not require the element of mens rea, and it can be proved only by establishing the element of actus reus, that is the physical element. And therefore, the moment the girl below 16 is taken away without the consent of the guardian, then the offense of kidnapping is complete. And therefore, Prince was convicted for the offense of kidnapping. Now, apart from the English cases, you can also think of some Indian cases on the topic of strict liability offense. And one such case was the case of Ranjit Udeshi. Now, in that case, Ranjit Udeshi was a vendor, and he was selling books at a bookstall in Mumbai. And what happened was that there was a book written by the British author D.H. Lawrence, and that book is titled as Lady Chatterley's Lover. Now, that book was actually obscene in nature. Its contents were obscene, but the accused person, Ranjit Udeshi, he was not knowing English language, and he was found selling that book. That's why he was arrested and later on prosecuted for the offense defined by section 292, that is distributing the obscene material. And it was held by the court that this particular offense of distributing the obscene material, as is incorporated in section 292 of the Indian Penal Code, this particular offense is a strict liability offense wherein mens rea condition is dispensed of. And since that condition is dispensed with, the court held that Ranjit Udeshi is very much guilty of the offense of distribution of the obscene material, because this offense is a strict liability offense, and the prosecution did not prove any kind of mens rea such as knowledge or intention on the part of the accused person. So even if the defense was taken that the accused was ignorant about the English language and the obscene contents of the novel, still he was punished by the order of the Supreme Court. So all these cases indicate that although there is a general rule saying that in order to constitute a crime, actus reus and mens rea must coincide, still in number of offenses, the condition of mens rea is not strictly followed, or it is not necessary as such. And these offenses are known as the strict liability offenses. And some examples of strict liability offenses, they include the offenses such as bigamy, the offense of kidnapping, then the offense such as adulteration of food. So if any person has adulterated the food, then the court will not inquire into his intention or anything related to mens rea, because it is established by the proof of actus reus alone. So this particular maxim, that is actus non facitrium nisi mens citria, it tells us that in order to constitute a crime or to impose the criminal liability, actus reus and mens rea, they must coincide. But this maxim or this principle is not hard and fast, and there are some exceptions to this particular principle. So this is about the essential elements of crime, and these essential elements are always to be proved by the public prosecutor in the court of law beyond a reasonable doubt. Then only the accused can be convicted and the punishment can be given accordingly. So with that, we come to the end of this particular session on the topic of Actus Reus and mens rea.